A judge has ruled that some key evidence in the Luigi Mangione case can be used in his state murder trial. Yesterday, the judge ruled that the gun and notebook recovered during Mangione's arrest in Pennsylvania is permissible in trial. However, the judge said other evidence, including a loaded gun magazine, cell phone, passport, wallet, and computer chip, were obtained without a warrant and cannot be used. For more on Mangione's case, I'm joined by criminal defense attorney and former Manhattan prosecutor Jeremy Saland. Jeremy, good to see you as always here on News All Day.
As well.
So why would a judge suppress some evidence from a search but still admit some other evidence from that backpack to be allowed at trial?
A key thing here was timing, exigent circumstances, reachable area. These are terms that we see in a court regularly with these types of motions. And I would like to add, first of all, as well, that this is somewhat of a single getting on base for the defense, though overall still a triple for the prosecution. But when you look at it here, what it came down to was there was an inventory search back at the precinct where the judge said you follow the proper rules and proper procedures, and you found that firearm and you found that notebook there back at the precinct. That was fine. But initially, when he was surrounded, meaning Mangione, and the backpack was roughly 9 feet away, there wasn't an exigent circumstance. There wasn't an issue of public safety. It wasn't in his reachable area or area within his control. So the judge said you did not search that necessarily properly, despite the claim that there was a bomb and concern of a bomb. But at the same time, the judge noted there were still people accessing the bathroom and employees accessing the storage area. So that came into question, and the judge says, no, those items that were found there initially, they don't come in, but the ones that were secured later on, those do come in.
Interesting. Let's talk about that notebook, right? How damaging could that be for jurors to see what is in that notebook and hear those writings?
Yeah, this is why I say, again, there was a single and some success, but a triple for the prosecution, because that is a big piece of evidence. That goes to the motive. They don't have to prove motive beyond a reasonable doubt, but nonetheless, that's going to be part of the narrative. It even goes to the intent and what was going on here. So that's a big piece of evidence to complete the story for the prosecution and say, how did we get to this point? How do we know Mangione's the guy who did this, in addition to all the other evidence like the video, for example?
We've been reminding our viewers we have the state trial, we have the federal trial as well. But where do you even begin with jury selection for a case like this? I mean, we always say this with high-profile cases. This seems particularly high-profile. How do you get impartial jurors?
Yeah, it's tough. Listen, I thought Trump's jury selection was going to go on for weeks. I didn't think it would be as quick as it was. But I think the difficulty here for the defense and the prosecution is making sure that you don't get that one or two juror who says, you know what, I'm going to say the right things. This is a sexy public case. I see this maybe about me, or alternatively, I see this about obviously the big picture of healthcare, and I'm going to get on it and throw this for a loop, because all you need is one for that mistrial, as we know from Weinstein. That's all you need. So it's going to be a tough process, but a highly vetted process.
Speaking of Weinstein, I want to get your thoughts on that as well. I mean, third time that this happened, do they try a fourth time, or is this case over at this point?
You rarely see two. I mean, it certainly does happen. Three, incredibly atypical. Four times, four bites out of the apple. At some point, you have to say, not to sound too flippant here, when the credibility is at question, and from what I read in the paper, one of the 9 of 12 jurors who said no go, no conviction, not proof beyond a reasonable doubt, question the credibility of the witness, meaning the complainant. At that point, you have to say, this is not about what appears in the public. This is not about Me Too. This is about maybe a bad guy. And in fact, a bad guy who's done some bad things and has been convicted of crimes, but he may not have committed this particular crime. He's not getting out anytime soon, if at ever, due to his age and his health. It's time to move forward and provide some closure.
A busy week in court. Jeremy Saland, good to see you as always. Thanks for coming on.
My pleasure.
Fabulous, a star.
Did you see how I